The idea-expression divide or idea-expression dichotomy limits the scope of copyright protection by differentiating an idea from the expression or manifestation of that idea. The European Union Software Directive, Article 1.2, for example, expressly excludes from copyright ideas and principles that underlie any element of a computer program, including those that underlie its interfaces. As stated by the European Court of Justice in Schacht Institute Inc. v. World Programming Limited, to accept that the functionality of a computer program can be protected by copyright would amount to making it possible to monopolize ideas, to the detriment of technological progress and industrial development. Legal scholars have described the idea-expression dichotomy as the ratio decidandi of this landmark ruling. In the United States, the 1879 opinion of the Supreme Court in the case of Baker v. Selden elaborated this doctrine, holding that, while exclusive rights to the useful art described in a book might be available by patent, only the description itself was protectable by copyright. In Harper & Row Publishers, Inc. v. Nation Enters, 471 U.S. 539, 556. The Supreme Court stated that copyright idea-expression dichotomy strikes a definitional balance between the First Amendment and the Copyright Act by permitting free communication of facts while still protecting an author's expression. Additionally, in Mazer v. Stein, 347 U.S. 201, 217, the Supreme Court stated, unlike a patent, a copyright gives no exclusive right to the art disclosed. Protection is given only to the expression of the idea, not the idea itself. Some of the criticism directed at intellectual property is based on the confusion between patents, which may confer proprietary rights in relation to general ideas and concepts per se when construed as methods, and copyrights, which cannot confer such rights. An adventure novel provides an illustration of the concept. Copyright may subsist in the work as a whole, in the particular story or characters involved, or in any artwork contained in the book, but generally not in the idea or genre of the story. Similarly, if the methods or processes described in a work are patentable, they may be the subject of various patent claims, which may or may not be broad enough to cover other methods or processes based on the same idea. Arthur C. Clarke, for example, sufficiently described the concept of a communications satellite in a 1945 paper that it was not considered patentable in 1954 when it was developed at Bell Labs. In the English decision of Donahue v. Allied Newspapers Limited ch. 106, the court illustrated the concept by stating that the person who has clothed the idea in form, whether by means of a picture, a play or a book, owns the copyright. In the Australian decision of Victoria Park Racing and Recreation Grounds Co. Limited v. Taylor 58 CLR 479 at 498, Latham CJ used the analogy of reporting a person's fall from a bus. The first person to do so could not use the law of copyright to stop other people from announcing this fact. Some courts have recognized that particular ideas can be expressed intelligibly only in one or a limited number of ways. The French name for this doctrine is science faire. Therefore even the expression in these circumstances is unprotected, or extremely limited to verbatim copying only. This is true in the United Kingdom and most Commonwealth countries. In the United States, this is known as the merger doctrine, because the expression is considered inextricably merged with the idea. United States courts are divided on whether merger constitutes a defense to infringement or prevents copyrightability in the first place, but it is often pleaded as an affirmative defense to copyright infringement. In August 2013, Robin Thicke, Farrell Williams, and T.I. filed a lawsuit against the family of Marvin Gaye regarding their song, Blurred Lines. The family had argued that Blurred Lines had copied the feel and sound of the Marvin Gaye song, Got to Give It Up, contradicting the idea-expression divide. In March 2015, a court ruled that, despite not even sharing the same chords, lyrics, or other copyrightable elements, that Blurred Lines had infringed on the copyrights of Got to Give It Up by copying its feel and ideas.